Good evening, everyone, and we are delighted to be here with Chief Judge Patti Saris for this very interesting conversation on the United States as the world's largest jailer. My name is Karthik Ramana. I'm a professor of business and public policy here at the Blavatnik School, and I'm also the director of the Masters in Public Policy program here. And it is our honor to invite Chief Judge Saris here to the school. She's had a long association with me personally, which she will speak about in a moment, but this is the first time that we're having her here at the Blavatnik School. Chief Judge Saris has been on the federal bench of the United States Judiciary since early in the Clinton administration. She was appointed in 1993, she has served in the United States District Court for the District of Massachusetts, so this is the federal court that oversees the state of Massachusetts, and is now the chief judge of that court. But she has, for the last 10 years, up until last year when she stepped down, served as the chairman of the United States Sentencing Commission, which is the commission that oversees prison guidelines for the United States federal judicial system. And it is on that subject that she will be speaking today. Chief Judge Saris is a graduate of Harvard College and Harvard Law School. Early in her career, she was an assistant U.S. attorney, which is a senior role in the Prosecutorial Service of the United States government, and spent a brief career in private practice before being appointed to the federal judiciary. Chief Judge Saris, welcome to Oxford.
Thank you. Well, good afternoon to everybody, and I'm very happy to be here, and thank you, Karthik, for that kind introduction. I'm pleased to be at Oxford for this symposium to discuss criminal justice, particularly federal sentencing in the United States. This is my second trip to Oxford because my husband was a visiting fellow at the Said School of Business and Real Estate last year, and I became friendly with Karthik when he was a colleague of his at Harvard Business School. But the real way that I got to know Karthik is when I married him. I was the officiating officer when I married Karthik and his husband, John, back in Boston a few years ago. So I was very thrilled and honored to be able to do that. I feel a particular kinship to England, as my son is studying, dare I say, here at Cambridge University. And he just married a wonderful woman from England, from the Cotswolds. So for me, it's great to come to Oxford, and it'll be great to give a hug to my youngest. So why am I here? We just passed the 30th anniversary of the United States Sentencing Guidelines. As former chair of the Sentencing Commission, a bipartisan agency within the federal judiciary, and current chief judge of the Federal District Court in Boston, I have been engaged in criminal justice reform efforts to address the effects of harsh mandatory minimum sentences for drug and gun offenses. As background, I was a staffer on the Senate Judiciary Committee working for Senator Edward M. Kennedy from Massachusetts in the early 1980s when sentencing guidelines were just being seriously debated. I've also been a trial judge, not just in the federal level, but also in the state of Massachusetts. I became chair of the Sentencing Commission in 2011. I was nominated by President Obama and confirmed unanimously by the Senate. I just finished last January 2017. In this speech, I hope to discuss the pendulum of sentencing policies from the 1960s to the 1980s to the present in the United States to answer the following question: how did the United States become the world's largest jailer? I've read that England has implemented a sentencing guideline regime to address disparities in sentencing. So what lessons have we learned in the United States about approaches to sentencing? As we go through this, I want to emphasize that I am no longer chair, so I speak for myself, not the Sentencing Commission. Now let's talk a little history. The roots of mass incarceration began 50 years ago as the United States faced rising levels of violent and drug crime. In the early 1960s, there were about 4.6 homicides per 100,000 people, and then the number doubled within a decade by 1974. And by the end of the 1970s, the country reached a peak of 10 murders per 100,000 people. Young people recruited into the drug trade were shooting and killing each other in the inner cities. President Lyndon Johnson was so worried that he established a commission on crime in 1967, which issued a mega report, hundreds of pages long, which began with the following startling statement: the existence of crime, the talk about crime, the reports of crime, and the fear of crime have eroded the basic quality of life of many Americans. The report then stated, there is much crime in America, more than ever is reported, more than ever is solved, far too much for the health of the nation. In the 1960s, 1/3 of Americans surveyed in high crime areas said it was unsafe to walk alone at night in their neighborhoods. 1/3 said they kept firearms in their house for protection against criminals. So what was the source of the crime back then in the 1960s? According to the Johnson Commission, young people between the ages of 15 and 24 committed a disproportionate share of the crime. In addition, many criminals were drug addicts. Finally, the report believed that the increasing violence in every section of the nation compelled an effort to control the firearms that contributed to the violence. Of great concern was the recidivism rate, because about 1/3 of offenders were re-imprisoned, usually for new offenses within a 5-year period in both the federal and state systems. In 1965, there were 4,000 drug violators confined in federal institutions. About 18%, say, of the federal prison population involved drug offenders. The report called for rehabilitation, for better prison programming, and for the elimination of mandatory minimums. The tone, when you read through it, which I did, was quite rehabilitative and not punitive, except with respect to the habitual violent offender. Interestingly, in 1970, under President Nixon, Congress followed some of the report's recommendations and eliminated many of the mandatory minimum laws for drug offenses to make sentences more flexible. That was the 1960s and 70s. 20 years later, though, the pendulum swung. In the 1980s, calls for rehabilitation and drug treatment were abandoned as liberal pipe dreams. Heroin and later crack and gun violence devastated inner-city neighborhoods. The rate of juvenile homicides doubled from 1985 to 1993, and the political leaders from both parties, including African-American leaders, called for action in terms of tough sentencing. Some cities, like New York City and DC, instituted aggressive policing strategies, which some have dubbed warrior policing, where young black men were stopped and frisked at high rates. With bipartisan support of Democrats and Republicans and a unanimous vote in the Senate, the Congress adopted the Sentencing Reform Act of 1984, which established the Sentencing Commission, which I then went on to chair. It was a 7-member bipartisan expert body within the judiciary, and it had to have at least 3 judges to establish sentencing guidelines to govern all sentencing in federal courts, and it went into effect in 1987. And then also to study what was happening with sentencing policy and practices. Initially, the primary goal of the Sentencing Reform Act was to eliminate unwarranted disparities among judges by establishing mandatory guidelines with a sentencing range anchored in the criminal history and seriousness of the offense. I remember then, because I was working for Senator Kennedy, I used to sit in the back of the hearing room, and I'd hear questions like, why should a bank robber in Texas get a harsher sentence than a bank robber in California? Why should it matter within one courthouse what judge you get? Why should one judge be able to be very harsh and another judge to be very lenient? However, elimination of unwarranted disparities was only one focus of the debate. There was a marked shift away from the rehabilitative model to a bipartisan desire for punitive measures. Congress sought to control crime using, and this is a quote from back then, more certain, less disparate, and more appropriately punitive sentences. So in 1986, under President Reagan, and again in the 1990s under President Clinton, harsh mandatory minimums were put in place. Let me give you some examples. For example, 5 and 10-year mandatory minimums based on drug amounts were incorporated in the guidelines, ratcheting up sentences for drug trafficking and contributing to an explosion of the federal prison population. This is how it worked. Say you had someone on a street corner selling 5 grams of crack. Crack is basically cooked powder. Say you had some person selling 5 grams of crack, 5 little sugar packets. That was a mandatory 5 years in prison. The judge had no discretion. 5 little packets of crack, 5 years. Take a kilogram of heroin. Let's think freezer bag of heroin. Or 5 kilograms, 5 freezer bags of cocaine. Mandatory, 10 years in prison. Most of the sentencing guidelines, the purpose of them was to reflect the average sentences judges imposed, for example, say in the area of street crime or immigration. But when Congress imposed that mandatory minimum, the Commission adjusted the guidelines to reflect the tough mandatory minimum. Congress also added a very draconian sentencing enhancement if the drug offender had a prior record. So let me explain. Let us go back to that one young man, usually men, standing on the street corner, selling his 5 grams of crack, but this was the second time he got caught. Suddenly that 5 years became 10 years at the discretion of the prosecutor. Or the 10 years, let's say for the kilo of heroin, suddenly becomes 20 years at the discretion of the prosecutor. By 2014, you could see how this happened. Drug offenders constituted a majority of the Federal Bureau of Prisons population. Remember, going back, because I know I'm spouting a lot of statistics here, back in the 60s, it was 18% of the prison population. By 2014, it was a majority of the federal prison population. I want to contrast a statistic, though, because that's true of the federal prisons, and of course, in the United States, we have federal and state and local prisons. But so in contrast, more than half of state prisoners are serving sentences for violent offenses. So there is a difference in the prison population between state and federal. So let me talk for a minute about gun violence. I've been focused on drugs. Gun violence was also rampant, especially in the inner city. In 1994, the Reverend Jesse Jackson said that more blacks had been killed by other blacks in 1 year than had been lynched throughout history. In his new book, Locking Up Our Own, Professor James Foreman, who's a fabulous book, I just read it if anyone's had a chance, he's a professor at Yale Law School, describes how inner city black community leaders in communities devastated by the drugs and the guns called out for harsher laws. During this period of time, tough armed career criminal sentencing laws went into effect with 15-year mandatory minimum sentences. Multiple crimes committed with a gun could be stacked, which would result in life sentences for first-time offenders. So let me tell you a particularly notorious case. So a young man with a gun in his belt sold drugs on 3 separate occasions. He was caught. I guess there must have been an informant or something. There were 3 separate occasions, and there was no intervening arrest. He received a life sentence. It was stacked, and this use of stacking is used in very different ways across the United States. I have been talking about the federal side. Let me talk for a minute about the state side. Tough mandatory minimum sentences were enacted into law at state levels as well, and state populations surged with violent and drug offenders. So the federal prison population peaked in 2012 with about 217,000 people. And the United States had become the world's largest jailer with over 2 million people in federal, state, and local jails. I need to sort of just stop for a minute when I talk about over 2 million in federal, state, and local. To some extent, some of these statistics are hard to get, for example, from jail populations in local areas. And so we've been relying some on the Bureau of Justice Statistics, but there's some differences as you look across the statistical databases. But well over 2 million people were in jail in the United States at the peak. The next closest was China, with about 1.6. And I have to say the UK, we were about 25 times higher than the United Kingdom, which has maybe about 84,000 people. And if you were to do it on a per capita basis, and once again, this depends on how you're counting jail populations and state, we were at about 666 per 100,000 as opposed to the UK, which is about 143 per 100,000. And those statistics deal with people in prison. That doesn't count the 4.6 million people who are on some sort of probation or parole or supervised release of some sort. So, while the mood in the 1980s and the 1990s was certainly punitive, I believe the few predicted the crisis of mass incarceration with its devastating effect on minority communities that was to occur 20 years later with 1 in 3 black men coming under federal, state, and local court supervision. Although African Americans are 13% of the United States, the population of the United States, they're 34% of the nation's federal prisoners. And once again, depending on how you count people, they're about 41% of state prison populations. At the federal level, by 2013, Black and Hispanic offenders made up a large majority of federal drug offenders, more than 2/3 of the offenders in federal prison combined, and 80% of those drug offenders subject to mandatory minimums at sentencing during this time period. It's changed a little bit, which I'll get into. But then, a generation later, the pendulum swung again, back in the late 1990s, as the rates of violent crime dropped to historic lows in big cities like New York City. They have started to rise again in certain cities. You may have read about Chicago in certain areas, but still, the rates of violent crime are at historic lows. Homicides declined back down to about 4.4 per 100,000 in 2014. I looked up all the data on UK to give it a contrast. UK has about 2 homicides per 100,000. By this time, though, the federal and state prison populations had exploded, causing severe budget problems. As I mentioned, the federal prison population peaked at 217,000, and predictions were, I was chair at that time, that the prison populations were going to continue to increase. So the Sentencing Commission, in a bipartisan way and unanimously, took action. In 2011, in a large-scale study of federal mandatory minimum sentences, the Sentencing Commission, Democrats and Republicans, and by the way, some of them support mandatory minimum sentences. I don't, but some of them did. But we did conclude unanimously that mandatory minimum penalties for drug offenses were set too high and applied too broadly. What do I mean by that? What did the report mean? It means they swept into these mandatory minimums, not the big, I don't know, in the United States, I don't know if it came Miami Vice type big drug dealers from cartels. No, these mandatory minimums were sweeping in drug couriers, what we call mules. They were sweeping in street dealers, and not just the managers and organizers that Congress had in mind. Facing budget crises, states you wouldn't even predict, states like Texas, South Carolina, California, took the lead in reducing state prison populations, and they did not see an increase in violent crime. When I became the chair, the Federal Bureau of Prisons was 37% over capacity, and the Bureau of Prisons was literally 1/4 of the budget of the Department of Justice, which runs the law enforcement. 1/4 of the budget was going there. So following the lead of the states, which did these innovative programs without seeing a tick up in violent crimes, Congress came into the picture, and Congress began to the federal Congress took action. Bipartisan legislation was introduced in Congress to reduce tough mandatory minimum sentences for drug and gun offenses and to improve reentry with prison programming at the back end. Relying on a statutory mandate to ensure that sentencing laws took into account prison capacity and to consider the proportionality and fairness of sentencing, in 2014, the Sentencing Commission unanimously, and again in a bipartisan way, voted to make an estimated 40,000 prisoners convicted of drug trafficking crimes retroactively eligible for a reduced sentence of on average 25 months. This is an unusual power that we used sparingly, but we retroactively reduced the sentences of up to 40,000 prisoners. Now, they didn't just walk onto the street. Rather, they went back to the sentencing judge, the trial judge, who would then evaluate whether that prisoner was going to pose a public safety risk. Most got a reduced sentence that went back to the sentencing judge. 6,000 prisoners were released on the effective date of November 1st, 2015. The commissioner had also on its own reduced crack penalties in 2007 and again in 2011. And it's something we learned from that, because as I said, we gathered statistics. We learned that even with reduced penalties for the drug offenders, we did not see an increase in recidivism for those people with the reduced sentences. And that gave us also some comfort that there wouldn't be a public safety risk. I'm proud to say that the prison population has decreased from its peak of 217,000 to about 189,000. State populations have also decreased. To address public safety, as I mentioned, we also did a study of recidivism. The Sentencing Commission has unbelievable data report, and we worked with the FBI in getting their crime data, as well as our own data on sentencing. We did a study of recidivism that followed prisoners for 8 years after release. Most recidivism studies go 3 years or 5 years. We looked 8 years after the release. We found that the length of incarceration, not including probationary sentences or very low sentences, but the length of incarceration does not affect significantly the amount of recidivism, which is about 50% on the federal level over 8 years. So the length of the sentence, except for the very lowest sentences, does not affect in any significant way the amount of recidivism. Of great concern is the impact of harsh sentencing on the minority communities. For those of you who are statisticians, I'm not, but we have this great team. Under a recent multivariate regression analysis, trying to make sure that we're comparing apples to apples, we found that Black male offenders received a guideline sentence on average about 19% longer than similarly situated white male offenders during the most recent 5 years. Many point out that there are also disparities in how prosecutors are charging crimes carrying mandatory minimums. For example, those enhancements that I was describing before. Let me talk to you about career offenders. Career offenders are those 3 strikes laws that you've probably heard about. It is 3 drugs or 3 violence, and they have on average about sentence length of about 12 years. So it's really if you become a career offender, it's a huge bump up in your sentence. Blacks are about 60% of those who are included within the definition of career offenders. And the biggest impact, though, on the disparity in sentencing has to come from the statutory decision to punish crack offenders 100 times more seriously than powder cocaine offenders. Most of the defendants who are found guilty of selling crack were African Americans. The crack powder disparity, as it became known, was 100 to 1. In other words, crack was being punished 100 times more seriously than powder. The Congress, finally realizing that this was unfair and disproportionate, Congress fixed this problem in 2010. But in the Fair Sentencing Act, but they only partly fixed it because they didn't make it retroactive. And so there are lots of people still in prison under the old crack powder ratio of 100 to 1. Even in my home state of Massachusetts, when we have a relatively low incarceration rate in Massachusetts, African Americans are incarcerated at nearly 8 times the rate of whites. These high incarceration rates have a negative impact on families, on communities, on the individuals in disadvantaged neighborhoods. As I said earlier, to address these problems, Congress almost passed, I have here underscored almost with exclamation mark, almost passed bipartisan legislation to reduce mandatory minimum sentences, which received wide support in both houses of Congress from both parties. But we ran out of time to fix the statutes in the last Congress. Towards the end of his administration, President Obama commuted the sentences of 1,696 offenders, many of whom were minorities. 60% of those were crack offenders because of those harsh sentences. 60% of those who got clemency were there on crack. And I just want to add to you, because the thing that sort of hit me when I became a judge and continues to hit me is the length of the sentences. The average sentence of the defendants commuted was 340 months. And the commuted prisoners received an average sentence reduction of about 140 months. The Attorney General, Eric Holder, lessened reliance on mandatory minimums as a prosecutorial tool of crime control, and he instructed his prosecutors to only charge mandatory minimums in the most serious cases. During that time period, the number of crack prosecutions have dropped by half. There is a limit to what the Sentencing Commission, the President, the courts, the Attorney General can do without statutory change. And we failed in the last Congress to achieve that. As you all know, elections matter. As an optimist, I see some hope for bipartisan legislation to address the over-incarceration caused by these tough mandatory minimums. The Senate Judiciary Committee just marked up a bill, despite opposition from the Attorney General. Also, I've read that the White House has been holding meetings on possible prison reform proposals. Remember, I was discussing that back end with better programming, which would give a prisoner credit for completing prison rehabilitation programs. I'm hoping some of these reforms succeed. Another glimmer of hope is that Congress, and I do take this as hope, Congress has not rushed to add yet another mandatory minimum every time there is a drug crisis. Right now in the United States, I hope it's not true here, we literally have something we're all calling the opioid crisis with heroin. The emphasis, though, has returned to treatment, not additional sentencing. There's been no harsh new mandatory minimum. Moreover, change is continuing to happen in the courts and in the states. Federal and state courts have initiated many reentry courts and problem-solving courts that provide alternatives to incarceration. And states are continuing at innovative efforts to decrease the reliance on bail and to reform fines, fines that may end up putting you in jail if you can't afford to pay them. So, and many other initiatives as well. So I thought what I might do, because I know we want to just have a long discussion about this, so there'll be a long question and answer period. I wanted to give you some of my takeaways when you look at the last 50 years of criminal sentencing. First, sentences, particularly in the area of drug trafficking, continue to be too harsh and disproportionate to the role many low-level, nonviolent offenders play, largely as a result of mandatory minimum sentencing. To that end, the Sentencing Commission's recidivism studies have proved that longer sentences do not reduce recidivism or improve public safety. Second, fear of violent crime and concerns about drug trafficking continue to play a major role in criminal justice policy. However, we must take a rehabilitative approach to solve crime issues like better treatment for drug addicts. A statistic that I found interesting was that 40% of the federal inmates have a significant substance abuse disorder. Only in recent years has rehabilitation come back into the equation. However, treatment programs need to be effective in protecting public safety to retain public support. Recent statistical studies show only mixed results from drug court programs in the federal courts. So we can't just throw resources at the problem without evaluating the evidence of effectiveness. I like to brag about the probation officers that we have in federal court because they've been particularly innovative in working on evidence-based practices for like cognitive behavioral therapy for those on supervised release. I believe that because of the differences in the resources, the money available, federal offenders have about 45% recidivism rate after 5 years. You know, that's a little confusing because you said, oh, you just told me it was 50%. Well, that's because we pulled it out another 3 years to 8 years. So to compare the state and federal, I looked at it, it's about 45% recidivism after 5 years compared to over 70% from state prison during that time period. And I think it's because we have more resources to supervise them carefully with the probation departments. Many courts are initiating alternatives to incarceration. In our own court, we have something called the RISE program, which is still very small, so it's hard to predict whether they're going to work and statistically be effective. You know, so far we've had maybe 25 people, and essentially we take first-time offenders or people with very small prison records and say we don't need to send them to prison. Maybe there's another option for them. For example, I sentenced a woman who was carrying drugs up on a plane from the Caribbean for her boyfriend, and she had a lot of drugs and she was looking at time, and because she was a first-time offender, she went through this program, and I'm proud to say that she got a college degree, and she also is working 2 jobs. So there are successes from it, but we've had failures as well. Too soon to tell, but the courts are experimenting across the country in trying to create these alternative programs. The new frontier for federal criminal justice efforts, though, is a concern about the collateral consequences of crime. I don't know if you have that here in the UK, but in the United States, if you have a felony conviction, it hurts your chances of getting a job, getting student grants, housing. You can't get into many public housing, and in many licenses you can't get. So the American Law Institute is looking at proposals, and many states are looking at proposals as to what to do about these collateral consequences. All right, my third takeaway. Over-incarceration has had a devastating effect on minority communities, which have historically been under-policed for safety and over-policed for incarceration. While recidivist violent criminals should get a long sentence to protect public safety, we need to be careful on how we define these 3 strike laws so they are not overbroad. The Commission is continuing to study mandatory minimum sentencing and has recommended reforms of the career offender guidelines so that they cover violent repeat offenders, but not drug repeat offenders, who have much lower recidivism rates. In the long run, though, as we all know, sentencing policy will not fix the crime problem. Instead, we have to have more effective community policing and attack the root causes of poverty. There's a new book out, which I've just finished, reviewed in the Wall Street Journal, called Uneasy Peace by Patrick Sharkey, which explores the history of broken window policing and a shift to a policing strategy which is less focused on arrests and stops and really is more focused on being guardians of the community. Policing has also become more data-driven so resources can be focused on where the hotspots are for crime. Fourth, sentencing guidelines are a substantial improvement over mandatory minimum sentences or completely discretionary sentencing, in my opinion. 75% of federal judges prefer an advisory guideline system to avoid unwarranted disparities to mandatory minimums or pure 0 to 20 discretionary indeterminate sentencing. Guidelines provide an important evidence-based approach and anchor to make sentencing decisions while providing flexibility to consider individual offender characteristics. Right now, 29 states have guideline systems, and so does the United Kingdom. While no sentencing system is perfect, I unfortunately have come to that result. All the sentencing systems have problems. I believe that sentencing guidelines and the statistical information generated by sentencing commissions are useful benchmarks for sentencing courts. However, we've learned sentencing guidelines must be proportionate and fair. We've also learned that overly punitive sanctions will lead to mass incarceration, which harms the community, the individual, and I think the respect for the justice system. So I thank you very much for inviting me, and I think at this point we might want to go and have some Q&As. So thank you.
So before we go to the question and answer, we are going to say goodbye to our friends on YouTube who have been watching this live. So thank you very much.